Please note that this episode contains references to sensitive subject matter. Welcome to Law Syrup, the show where we talk with special guests about hot topics in Canadian law. This podcast is a co-production with the Ontario Justice Education Network, also known as OJEN. I'm your host, Herman Wong. Let's tap in. Before we begin, please know that this show is not intended to be legal advice or a replacement for a legal representative. Welcome back, everyone. On this week's episode, we will be sharing a recording from this year's Summer Law Institute. For those of you who don't know, the Summer Law Institute is a 2-day event hosted by OJEN at Osgoode Hall in downtown Toronto for secondary school law teachers. One of the programs this year was a conversation with Megan Savard. Megan is a criminal defense lawyer, and she has been counsel on many high-profile cases, including the recent Hockey Canada trial. In this conversation, we have OJEN's very own Jean-Paul Bevilacqua speak with Megan about her career, her perspectives on criminal law, prison abolition, and the role of defense in the administration of justice.
Thank you, JP, for having me. It's great to be back at OJEN. The last time I worked with OJEN was, I think, 2008, when I was a law student, so it's good to be back.
Before we get to that trial and Megan's experience, just wondering if you could take us a little bit back and talk to us about your first memories about the law.
Well, as a white woman, my first interaction with the law was positive, like many people who have my profile, and it wasn't until I got much more involved in the criminal defense side of things that I got to see a little bit how this particular vehicle and industry can operate to the detriment of the people the state is supposed to be protecting. For me, it was really, I almost stumbled into it. I didn't have any educators like the ones in this room to instill in me a love of civics or the law when I was in high school. So I took an English degree, realized that I had no marketable skills, flipped a coin, took the LSAT, decided I would go to law school, picked the law school based on a list I saw, I think in Maclean's, so really very thoughtless all the way through. And then it wasn't until I got to law school realized that 99% of the law I wasn't particularly interested in. The theory of the law was interesting, but really just wanting to ply my trade and help human beings, I started gravitating towards criminal defense in particular.
Those Maclean rankings, such a throwback? Like, do they still do that?
I don't know.
Okay.
I haven't read Maclean's in a while, but I assume so.
Yeah, interesting.
What school did you go to?
University of Toronto. Thank you, Maclean's.
Not a bad one. And so you talked or alluded a little bit to this, but did you head into law school with an interest in criminal law? Was there something that you did that kind of engendered a reaction in yourself? Like, how did you end up choosing that specialty?
No, I headed into law school with no interest whatsoever and hopeful to find my path, and I did not find it in the classroom in first year law school. And the reason for that is it is very theoretical, but thankfully I was able to work at Downtown Legal Services, which is the University of Toronto affiliated poverty law clinic, in my first law school summer. And that was really what drew me to it. I practiced to the extent you can as a student, admin law and criminal defense law, had my first real clients, and got to experience, again, like I said, a little bit of the way the deck is stacked. And I would say that really piqued both my contrarian streak, the desire to be on the side that isn't necessarily well represented, that may be misunderstood, and then my clients are just lovely people and having a terrible time. And to be there for someone in what might be the worst moment of their life, or one of them, became a huge draw for me.
So what I'm hearing is like the human connection piece was huge for you, which, having been to law school myself, is, not always, maybe it's changed and I hope it has, totally or wholly emphasized, especially in those first year courses. I'm wondering if there's a specific interaction or person or case that you dealt with at Downtown Legal Services that stays with you to this day in terms of igniting that path within you?
Yes, actually. I was thinking about that on my way here. I had one client, I won't name him, he had no criminal record, and he was charged. He was an elderly Rastafarian man, which becomes relevant to the story, in his early 60s, and he was charged with a very minor domestic assault. Now, normally, because of where he was located in the city, he would have gone to Osgoode Hall's, York University's poverty law clinic. At the time, they had a blanket policy not to accept domestic assault cases where the perpetrator or the suspected perpetrator was male. And so all of these domestic assault cases came flooding into downtown legal services, and I went into that job with a set of preconceived notions about the kind of person who gets charged with domestic assault. My client was lovely and gentle, and as I studied the evidence in the case, it became clear that it was not nearly so clear-cut. In fact, he was the one who had called the police. His domestic partner, a woman, was bigger, younger, stronger than he was, and there was a policy at the time that you have to pick one. Toronto Police Service has to leave having charged or cautioned one person, and so they charged him. And he wasn't facing jail time. That's why I was allowed to even put my hands on this case as a student. But I was looking for something to back up his story, that in fact he was not the aggressor in this situation. And I went through some of the photos, and I saw a photo that the content of which I didn't recognize. And I asked him, what is this photo? He said, those are my dreadlocks. And they were lying on the floor where his partner had pulled them out of his head. And so that was, there's rarely a smoking gun in cases like that, but it was the kind of thing where, combined with the minor nature of the charges, I was able to get the charge withdrawn with no consequence to him, legal or otherwise. And that was really a profound moment for me, because I could feel my own assumptions being challenged, and I was able to make a real difference in someone's life. And I was able to do it when he'd been categorically rejected by a sexist policy from another institution, which I understand has now been changed and long ago. So it just really made me think about my own assumptions and those that we all come into contact with the criminal justice thinking about, and it did stick with me for that reason.
And so it seems like acting as Crown was never on the table for you.
No, I did try to interview with the Crown. I think I may hold the most records for interviews conducted versus jobs not offered. It was just immediately apparent, I think, to everyone in those interviews that I was in the wrong place. And so that, interviews are a great place to find out who you are, as well as to get the jobs that you want.
Yeah, especially if you're not pretending in an interview, which it doesn't sound like you were doing. So, so moving out of law school then, thinking about, you're a young lawyer, early stages of your career, did you think about, I need to make my mark, or were you just one choice after another? How did you choose what to do after law school?
I think I did think about that. I was, early on, much more so than now in some ways, I was intentional about my career. I think when you aren't established, and I don't come from Toronto, I don't have lawyers in my family, I was trying to think how I could get my foot in the door in the way that it would stay. Because in criminal defense in particular, there's just a massive attrition of mid-level female lawyers. They tend to go to the Crown, they go to other areas of law. It's a pretty hostile industry for people who want to build a family. And so I really wanted to establish myself as much as I could early on, thinking I do want to have a family, and I want to be able to do so when I'm in a place where people will accommodate that and understand that even though I now have to take time for my family, I'll be back and I'll be...
So we're talking in terms of the family consideration, the work-life balance piece, is that what we're talking about? Or is it the dynamics of the job? Is it the types of matters that you're dealing with? What is the hostility there?
It's a little bit of both. And, I appreciate work-life balance in quotation marks, because it really is just a matter of, sometimes if my kid is sick, I'm free to take the afternoon off, but then I wake up at 4 a.m. to finish the work, right? There's that piece. But what you find when you're in criminal defense is it's a lot of external deadlines. You just really don't have the ability to control your own practice and your own workload the way you would like, and you're in court, which is like being in an operating theater. You can't check your phone, you can't call someone if the judge says we're going to sit late. You can't say no without risking being held in contempt. And the daycare starts charging by the minute after 6 p.m. I see a lot of people nodding at that one. So it is. There's a lot of people, especially given the attrition of women, who don't necessarily appreciate what it looks like to run a full practice and to also have a family life. And so I wanted to at least have a bit of a reputation and a sense that people trusted me by the time I got to the stage of having to stand up in court and saying, I have obligations, I need to leave.
And now, did you find people at that stage that were supportive of this desire on your front to stay in the profession, in a specific field? Did you start to get mentors at that time in your career? Did you find that people were there to nurture you?
Yes, actually. So mentors and peers. There were women who were a little ahead of me, who had children slightly older, who would give me the cheat codes. And then my then boss, later law partner, Frank Addario, was also really instrumental. And that's a good example of someone who already has all the privilege using it for good. I think I was the first female criminal defense associate in the city who got any kind of top up for parental leave. And then, of course, I immediately told all my friends, and it became much more of a standard market thing. But that was a big deal. Frank didn't have to do that. He could have said no, and what would I have done? And so the fact that he was willing to create a new precedent in that way made me feel a lot more welcome, and I think a certain amount of loyalty to him when I came back, and that it was really good for our professional relationship as well.
And so how long were you together in that firm, and then when did you decide to branch out on your own?
It was 8 years. 8 years. So, and then in January 2021, which is the absolute best time to do anything new, right at the middle of COVID, was when I started my own firm.
And what spurred that on?
I think it's a combination of things. I love Frank, as I said. We still have a good relationship, but he was very much already at the apex of his career when I joined his firm, and the dynamic was always going to be he's the dad of the firm and I'm the teenage babysitter, so to speak. It wasn't a place where I could control the direction of it, set its values, and really shape the business in the way I wanted to. And I have a pretty healthy anti-capitalist streak in my nature. I really liked the idea of running a firm that was a lot more laterally organized, horizontal, involving everyone in decision making, opening up the books so that everyone can see where the money comes in and where it goes. And that was the kind of thing where I had to start it myself if I wanted to do it. And so it was a friendly breakup. I told Frank, I think 4 months before I left, what I was thinking of doing. He supported me. We worked it all out, but it was sad, right? Because you're giving up a known good thing for the hope of something better, and that always feels like you're doing something a bit crazy.
Yeah, and truly, like, what a time to be doing that. But from the perspective of someone in the profession, you've really continued to carve out not even a niche, but a real reputation and what you're known for. What do you think that is about? I know it's kind of like, let me compliment myself, but really, what do you think that you presented or offered that was maybe missing in criminal defense, or just the profession generally? What do you think Savard LLP represents to those seeking representation?
I think it's, I would like it to be more than just a reputation that's built on the cases that make the papers, because that's a very specific type of case. I know we'll speak about that. And it's actually quite a small part of my practice. The thing that got me into criminal defense law was trying to level the playing field. And what I hope it offers is, or what I'd like it to offer if I'm thinking aspirationally, is just a 5-star experience at a price that is on a sliding scale, right? It's a bit of a Robin Hood model. I obviously have private clients, and sometimes I worry about the fact that I couldn't afford myself if I got in trouble, but I keep minimum of 30% of my practice is either legal aid or pro bono, and usually large cases, murders, or something that's very much, I would say, of the same type as the cases that got me interested in the first place, right? Cases where maybe some colleagues aren't touching them, they're maybe politically unpopular. I've done a ton of protest cases in the last couple of years, for example, because that's been an area where freedom of expression and the criminal law have intersected in a really interesting way. And I think being able to offer clients that level of service, informed by the type of interesting work that normally you only get on a legal aid certificate, is what makes our firm unique. And hopefully as well a feeling that they've got someone on their side in a real sense. I don't put many limits on who I represent and who I don't represent, but we do have a no police rule. So we don't represent officers who are charged in the line of duty. There's no direct conflict there, but most of my clients are there because of negative experiences they've had with the police. And for them to meet someone in the waiting room or to feel like, I'm actually on the side of state excess in some cases, was something I didn't particularly want.
So
I don't know if that answers it.
No, it does. I just want to go a little bit further into that and talk about how you decide about which cases you take on. And then I'm wondering how it squares with clients that you may not find as sympathetic or who have potentially done something that you disagree with. What is that matrix like? How do you balance and how do you decide?
The simple answer is 2 out of 3. So I have this little triangle, and every case that comes into my office has to have at least 2 out of the 3 criteria. So it either has to have very interesting or novel legal issues, that sort of scratches the intellectual precedent-setting itch. Sympathetic client, it calls me back to the human nature of the work, and it just is always better if it's someone you enjoy spending time with, you want to help situate them as well as you can for the rest of their life going forward, or pays the bills. So any 2 out of the 3. And so yes, I have had clients who paid the bills and their cases raised interesting legal issues, didn't particularly love them, wouldn't necessarily be the clients you think either. And the really tough cases are the ones where you take it on, something changes, and you find that, now you're down to 1 or 0 criteria. And then, of course, you're limited ethically in your ability to get off the record. But overall, I think it contributes to job satisfaction. And it also takes my own personal feeling out of the equation, because the last thing I want to do is be unchecked in some of my biases and let that infect on too many in too many cases the type of work I take on.
Is that like a muscle? Like you struck by that, taking your personal feelings out of the equation? Is that something you developed, and did it come naturally to you? Is it something you're now pretty adept at?
It is definitely a muscle, in the sense that the more deliberately you try to force yourself to check yourself, the more naturally it comes. And I also think there's safety in numbers. I run a firm, I think I am the only white person and the only not minority person in some way. So part of what I do when I think about taking on a new client or a new cause is I open it up to the group, right? Because my racialized or queer associates might have a different view about a file that I'm considering. So any gray area file where I'm not sure, we do open it up to the group. And part of the rule too at my office is if anyone doesn't want to work on a particular file, they don't have to. But so far there haven't been any internal conflicts like that, because we're pretty consistent in what we agree to take on.
That sounds like a fantastic model. I'm really walking the walk of that lateral. distribution of power, I guess it might be.
Yeah, I mean, that's the goal, right? So, and sometimes I really do hate the democracy of it. As a manager, it's very easy. It's very easy to be a bad person when you're a manager. And you can feel that urge to treat your associates like inventory just creeping up into the back of your head. And my associates collectively bargain. Every December I get an email from them with their wish list. And I always have to go just take the rest of the day off and have a beer so that I can come back to it with the sort of objective mindset, knowing what I want my workplace to be and not give in to some of those really more, I guess, super villainy thoughts that sometimes come to you when you're the boss and you have the at least potential to exploit or profit off the people working for you.
I think that's so cool though, because it's easy to hold beliefs and then to actually put them in action. It's different and can conflict with your own personal wishes, desires, and self-preservation, right?
Yeah, I think choosing to be a good person, it turns out it feels very different than thinking you're a good person or feeling like a good person. They're two very different things, but like you said, it's a muscle, and hopefully over time I'll get there.
I think you're well on your way, Megan. Okay, let's talk about what many of us are really interested in talking about today. Mm-hmm. How was that Hockey Canada case and trial?
So as I said to JP, I'm going to share what I've said publicly and what is available to be shared publicly. I won't speak about anything confidential or privileged for this case. But I would say a few things stood out to me. First is obviously the level of scrutiny. I'd had some experience with high-profile cases before, but this one really, I think, ignited interest because of the intersectionality of it. Canadian values when it came to sex, when it came to sport, especially our national sport, when it came to the criminal justice system, all really dovetailed and everyone had thoughts about it and no one was neutral, including people in my own family. So I would say just the sheer amount of scrutiny that was placed on us, myself and my co-counsel, the counsel for the co-defendants as well, made it different. The other two things that made it different were the number of defendants charged and what that meant for running the defense. Part of being a criminal defense lawyer is in some way, marching to the beat of your own drum and striking out on your own course and having to live in a courtroom for so many months with 4 other legal teams, not all of whom necessarily approach the issues or the strategy the same way, was a really interesting challenge. And learning how to work with and around people who maybe think about the law a little bit differently or think about their clients or the role of the media a bit differently, that was really interesting. And finally, I'd say this case is unique, and this is something I've said publicly, in the sheer weakness of the case. I think it's probably pretty well known that when it was first investigated, no charges were laid. And the facts that led to that decision back in 2018 came out in full at the trial. And so I would say my disappointment with the fact that this was going to trial, it was heightened in this particular case because something I say to every single one of my clients, whether they're a defendant or sometimes I represent witnesses as well, is trials are never vindicating, right? No one comes out at the end of a criminal trial thinking, man, I feel good about that. I have really, really shown everyone who I am and what I stand for, and I feel amazing about how that's being portrayed and accepted by society, the judge, my family, etc. No one comes out of a trial like that. Witnesses, defendants, and so having to go through that trial when it was a massive financial burden on the state, when it obviously had major economic consequences for our defendant clients, felt frustrating in a way it normally isn't.
So is your opinion then that the Crown probably did not have a probability of conviction and shouldn't have brought it forward?
It's a tough question to answer, not just because I won't speak about
Sure.
confidential information, but because individual Crown attorneys are really limited in how they exercise their discretion. There is a Crown policy manual in Ontario that says, for example, restorative justice is not to be offered in sexual assault cases, which can be very tough, especially if you have a case like the one we're talking about, where anyone who's followed it in the media can see a pretty big gray area there, at least morally, if not legally. I might be able to say, legally, I think this case shouldn't have been brought. Do I think anyone comes out of that case looking good? Not particularly. And I think that pushing it through an adversarial model really just discourages any kind of nuanced thinking about it, right? You could never go to someone who is facing years of jail and say, okay, but let's explore how you might have contributed to this situation. They're going to say, why are you trying to treat my diabetes? I have a gunshot wound, right? And so that, and the same thing for a witness who's told you're going to be challenged, you might be on the stand for days, any amount of nuance in your story is going to be exploited. They'll double down on a version of events that may be, at best, under-nuanced, and at worst, and frankly quite common in some of the cases I see, deliberately not true. And in a way that's not unsympathetic, right? Someone who has been told their whole life that there is no excuse for choosing certain types of sexual behavior is going to find it attractive to remove the element of choice, especially if they're talking to someone like a parent or an authority figure that may not be the person who they'd normally want to be the most honest with. And so taking the nuance out of it, I think is it's really such a terrible thing. And allowing these gray area cases where people are willing to meet in the middle, to proceed down that route, I think would have been a great way to deal with a case like this one.
Yeah, it's only, I think you mentioned nuance. I mean, that was not present in terms of the societal political discourse around it. Very black and white, not too much interest in even exploring, acknowledging gray area. I thought it was interesting, and I watched the post-verdict press conference, and you talked a little bit about the differences in the style and approaches of the other defense counsel. And you were the only one that mentioned restorative justice. And I think I'm okay to say, because you said it outside the courthouse, that your client would have been open to that process and to be named publicly. Why did you think it was important to highlight that? And why do you think that this case, or sexual assault cases in general, may actually be suited for restorative justice?
I think, first of all, not every case, right? There are obviously cases, if you're talking about, a minor and an adult or someone in a position of power, that are much more clear-cut and not suited to it. But sexual behavior generally among adults is the very type of thing that defies black letter law and forensic reconstruction. The whole idea of sexual behavior is you are kind of supposed to take your brain out of it. And so to then ask people who have gotten into that state to go back, recreate what happened for a judge who doesn't care anything about your history, doesn't know what kind of a person you are, and have them decide what reality is or what happened in that room, it's particularly ill-suited to that sort of forensic analysis that is the bread and butter of criminal cases. And similarly, I think it's, by the time a case gets to me, it really is a Band-Aid solution for a problem that had its roots deep in the past, whether it's my client's past, the complainant's past, their parents' past. There's a whole world that contributed to everyone getting there. And one of the things that you can do, for example, a young man with a large platform and a bunch of other young men willing to listen to him could do, is provide a certain amount of education on how, for example, legal consent sets both too high and too low a bar for how we want to behave when we are human beings operating in society. The responsibility you have if you're literal bigger person in the room. And those conversations just can't happen once you've put people in their respective corners.
And now I acknowledge and realize that I'm a man asking you this, and there may be some unfairness in even asking the question, but I do want to pose it to you because it was so present in the discourse, so wonderful, I say that sarcastically, opinion piece in the Toronto Star about female defense lawyers and basically how do they sleep at night, how do they look themselves in the mirror, any other metaphor you want to insert there. How do you think about that? Is that a separate conversation? Is it one worth having? Does it interfere with your work? You mentioned some family members that you may have had conversations with. How do you, I don't even want to say reconcile, but like how do you interact? Like what's your relationship with that argument?
I think it matters that I'm a woman. I'm not one of those people who would say any lawyer can do the exact same job and there's no difference. I think it matters in these cases, actually, but I think it matters in a good way. And I would reject what I'd call the carceral feminist argument against me doing this work, because if you accept that criminal defense work is a necessary job, and you accept the premise that people should only go to jail if the crime is proven beyond a reasonable doubt, then what you have in a lot of these cases is a really tough situation where the Crown Attorney has, in some cases, abdicated its discretion, put its entire case on the back of one civilian witness who's probably never been in a courtroom before. It's very hard on any evidentiary record to get to proof beyond a reasonable doubt, as it should be, because you're looking at putting a human being in a cage at the end of it, but it's still really hard on that one witness. And part of being a woman doing this job is you can do this necessary work and bring to it, nonetheless, a level of empathy and I wouldn't say that almost common feeling with that witness in a way that some co-counsel cannot. And I will say, I worked with some very ethical male co-counsel in this case. We would moot ideas, and one of them might say, oh, I think this, or I think this is implausible. And then if I turned to them and said, actually, that's not implausible, I could see as a woman how XYZ might actually happen. That would be something that does make sense to me. And they would listen and they would learn a little bit from it. So taking women out of the room, I think, risks removing the little bit of nuance that you can infuse into this proceeding and the little bit of empathy that you can bring to a cross-examination. And taking us back to a world where the only strategy was to quote unquote whack the complainant. There's something about having been in similar social situations that allows you to make eye contact and say, look, I get it. You don't want to talk to your mom about things that you think she won't approve of, right? And getting someone nodding along with you a little bit, not every party are cross, but that kind of moment where you actually are able to show you're not just a stranger intruding, but someone who's just had more of a set of common experiences.
That's so interesting. I want to talk to you a little bit about your strategies around cross-examination, not specific to this case, but how do you think about your approach? Like, I mean, do you your tone dynamic relating to the complainant, does it change based on who is in front of you, or do you kind of have a baseline from which you operate? Like, how do you think about I'll call it the performance aspect of it. Like, how do you think about that? Like, how do you think about what type of energy you're entering the courtroom with?
Well, as you've alluded to, I have a full range of energies that I can bring.
Yeah.
And I would say that it really depends on the witness, right? I often have my cross-examination mapped out in the sense of the broad points I want to make, but how I make those points really varies, right? If you have a very emotional witness, a witness who's very honest about the limits of their memory, a witness who seems to be trying their best to actually comply with their oath, then it's a very different energy than if you see someone who you think is trying to game the system a little bit. And one thing I have no patience for is people who don't take their oaths seriously, and people who try to avoid answering questions because they don't like the way that the answer will sound. And so it can be that it switches as different topics come up. If I get the sense that someone is trying to be evasive, or if I've heard them say under oath something that I know they said the opposite thing, if I know they said the opposite thing 3 years ago, then it's almost like my mom voice comes out a little bit, like, well, come on, let's be clear here. You're saying this now, but you said the opposite 3 years ago. And it really is the same voice I use with my kid when they're trying to get out of trouble, because children tend to lie a lot, especially when they're very young. It just comes to them very naturally. And so I think my mom voice does come out a lot, especially if I get the sense that people aren't respecting their oath.
I'm glad I haven't personally raised that in any of this talk, but I know that we still have some time left, so I'm still a little scared. I'm just wondering if you think about a little bit of distance now, right? It's been a few weeks. I know you said that people don't leave a criminal trial feeling vindicated. Do you have hopes for its impact more broadly, maybe, in terms of, I'm thinking about two worlds, the sport and then the justice system, our legal system.
I have hope for society and sport because of the young people I know. And I'm sure many of you in this room would say the same thing. The level of openness and nuance that young people are capable of, especially when it comes to talking about sexual subjects, is unparalleled. It really is a breath of fresh air to talk to my child or my niece and hear just how open they are and how supportive of their friends they are and how willing they are to depart from some of the very restrictive sexual norms that I think guided me and a lot of people of my vintage when we were growing up. So I have hope for that. My best friend actually works out at a gym that is populated largely by Hockey Canada feeder athletes, and so she heard during the trial just these incredibly nuanced conversations among 14 and 15-year-old boys athletes. And so those little vignettes that I get into that generation do make me feel very hopeful. And learning what I did about hockey and the way we treat these young athletes as they're growing up, the way we sort of just pull them away from their families, stick them with a billet family, and then train them like they're gladiators to entertain us. We really are the true villain of the piece on some level, and I think that culture is changing. But the legal system, I don't know, my jury is out. The last couple of times there was no pun intended. The last couple of times there was a very high profile case that led to an unpopular verdict. There was some very performative, reactionary, and ultimately ineffective steps taken by what was then the Trudeau government. And largely the outcome of that has been it takes these cases longer to get to trial. It's more expensive for the people charged, it eats up a lot of court time, and now more cases are getting thrown out for delay. So I worry that, I hope that there will be positive consequences. I hope that maybe we can reopen the restorative justice conversation. What I fear is that there will be some kind of similar reactionary, poorly thought out effort to make it easier to convict and treat that as solving the problem once we do. Because the problem is not just laws that make it easier to convict, it's dusting off your hands at the end of that and saying, well, now we've made these laws, we don't need to worry anymore about the problem of sexual violence and sexual violence against women in particular, which, as we all know, is not the case. We do not change sexual behavior and attitudes just by making it easier for the few people who get prosecuted to completion to get convicted.
I would like to open it to some questions from the floor. Okay, right back here.
Great. So I work at a sports school, and there's a large chunk of students who are who play OHL and AAA and some NHL players. And so in the law classes, I'm going to be featuring you in the Toronto Life article. So I have two questions. One, we're going to talk about consent and ethical behavior versus criminal behavior, if you have any advice for that. And the second one is we're going to be talking about your prison abolitionist. If you could talk a little bit more about that, that would be great.
I love when, first of all, just to, I didn't want to be asking more questions, but I really want to talk about abolition because that was such a, thankfully, heavily featured part of your profile. So I'm so glad that you raised both of those. So thanks.
Yeah, I was surprised that Toronto Life even agreed to talk about prison abolition. Right. I thought that was just a little throwaway I was giving her. So taking it in reverse order, I am a prison abolitionist in the sense that I believe that the resources we currently use for prison, almost to the dollar, could be better used, invested in preventative measures that remove the need for prison altogether. That is nice. Not everyone reacts that way. And it is what keeps me going in cases where, we talked about that triangle of the perfect client, where some of those criteria do disappear, or a case where you worry about whether or not the justice system is even capable of completing the search for truth. If you start to realize the justice system is a poor construct and we almost never really get to the full truth, and you focus instead on what the outcomes are for people who proceed through the trial process, the vast majority of the harm that gets caused is to not just the person who goes to jail, but their families and the generational trauma that results. The number of clients I have who are my clients because they didn't have, for example, a father figure because their father was serving time in jail is quite high. And so that tends to keep me going, even if I'm not quite sure otherwise where I fall on the facts of the case or my role in the justice system. In terms of consent, I can echo, I think, what I said earlier, or maybe emphasize it, which is that the legal bar for consent is both too low and too high for what we want to be doing and what we should expect of ourselves as human beings. It allows for the criminalization and the labeling as sex offenders of people who have done nothing more than what society has told them is either permissible or something you can get away with. And the level of punishment and the level of condemnation that attracts is disproportionate to what I think the level of fault is. So in that sense, the bar is too high. But it's also too low in the sense that the legal definition of consent has nothing to do with enthusiasm, satisfaction. I can consent to go visiting my great uncle at the hospital, and I choose to do it, but it doesn't mean I'm going to have a good time there, right? And surely, and this tends to work, especially if I speak to young boys, surely you want to be able to walk away from an interaction feeling like a pretty good person, right? Like you've given someone something good to talk or think about, or whatever it is that helps make you feel like a man, right? And I feel like that legal definition of consent and this whole idea of, getting consent videos, yes, it's useful circumstantial evidence in a criminal case, but it's no substitute for actually making sure you've got engaged, enthusiastic participation, because then you don't even get a complaint, right? The fact that you're acquitted is a bit of a hollow victory if you know you've left someone unhappy enough to bring a complaint in the first place.
Okay. Right over here. Yeah.
Okay, to write this one down. In sexual assault defense cases, what would you say is the extent does appointing a lawyer from a diverse background reflect a genuine commitment to equity and representation versus a strategic deployment of diversity to construct credibility to shape the public perception?
Is this the Heather Mallett question?
No,
Yeah, no, it's a really good question because especially when you're thinking about jury cases, there is a little bit of performance to it, right? You think, how is it going to look to the jury that I'm there defending this person? And so do I think that some defendants take that into account when they select their lawyers? 100%. Can't stop people for picking lawyers for the wrong reasons. Certainly there are enough defendants who pick male lawyers because they think they'll be aggressive and effective in court, and they aren't always right about that. So we can't control why our clients pick us. What we can control is our awareness of our own particular brand of diversity and how we can use that to both effectively advocate for the outcome that we're routine to try to achieve, but also to minimize harm in the process. And I learn a lot about that from my associates. I have a couple of associates who are visibly Muslim, and the last case I had before the Hockey Canada trial involved a very similar gray area case where the complainant was Muslim and came from a very traditional family. And the benefit to my cross-examination of having those associates weigh in on what would be a fair question, what would be an unfair question, what would be genuinely implausible versus what is just a cultural blind spot for me as a white woman, that was very, very helpful. And I do think it advanced the search for truth as well as made my defense more effective, because nothing gets a witness's backup and gets them in the mood to start saying no to your questions like being misunderstood, right? You want to be able to correctly put the first 9 questions to them so that they're used to saying yes, so that they think, okay, this lawyer actually does get me a little bit. And that actually is a very effective strategic tool. It's also something that doesn't trade on myths and stereotypes. So I hope that's an answer.
Oh, okay, we got it. I thought there was, yeah, but yeah.
So you and your client, your team, made a very strong decision to have your client take the stand when the other clients in the case didn't. I don't know how specific you can get about it, but can you speak to how that decision was made, or how those decisions are made in general for like a sexual assault case? Because that was a pretty big, glaring difference in the trial, a big conversation piece.
Yeah, so I won't answer it in terms of this specific case, but I can speak a bit about the decision-making that goes into the choice to testify. First of all, the most important thing to know is that's never my choice, right? This is one of the few choices in how to run a case that belongs entirely to the client. So I have had clients where I said to them, look, do not testify. That is a terrible idea. You will get yourself convicted, and they take the stand anyway, and then I run with their choice. As long as they feel empowered, that's all I can do. So it's always the client's
Are you right,
decision.
generally?
I like to think I'm always right, but have there been cases where I thought the client should have made a different decision and the outcome was nonetheless what I hoped? Yes.
Okay.
It is one of those cases where I would love to, secretly, this is the bad manager part of my brain, I would love to be able to control it. You just can't. You just gotta be there to help them feel like they've had the process they're entitled to. The other thing that makes a difference is who you are trying the case before. So juries and judges are different. Judges are much more used to the idea that the prosecution has this burden, right? So they're kind of used to the idea of turning to the Crown saying, okay, have you put forward enough believable evidence for me to convict beyond a reasonable doubt? If not, I throw the case out regardless of whether I hear from the defendant. And because judges are used to thinking that way, you often don't feel quite as much tactical pressure to put your client on the stand and have them tell their story. Whereas with a jury, there is that residual feeling like, well, surely if there was something good to say, it would have been said. The final thing, and again, not speaking about this case, but you may see some parallels, is has that story come out in another way? Right? Do you want to put your client on the stand and expose them to the risks, obviously, of testifying? If, for example, the Crown has already played a police statement as part of their case where they say, this was innocent conduct. And so it is extremely rare for the Crown to do that. This was a very unusual case in the sense that the Crown did that with 3 different players' statements. But certainly the fact that the Crown is putting forward my client's, quote unquote, innocent story as part of its own case would be a factor I take into account in giving that advice.
Alan, yeah.
Is your spouse or partner also a lawyer?
My child's father is a lawyer, and my spouse is not, which is a fantastic thing for family harmony, and also sometimes to get his take on whether or not I've drunk too much of my own Kool-Aid, right? When you spend all your time with people who think the same way as you and who have the same esoteric set of beliefs, values, and assumptions about how people think, it's great to be able to come home to my very much not legally trained spouse and hear him say, well, actually what you're saying doesn't make any sense to me, right? Just every man in the back of the courtroom is a role that he's very good at playing.
Okay, let's go over here, yeah.
My question is about something you said previously, Megan, where you said that the Crown's whole case, relies on that one civilian witness who has never been in the courtroom. It's difficult to prove beyond reasonable doubt. How then can we move forward in getting convictions where that's what? Like, if you're only ever relying on that one witness, how are we going to move forward getting convictions when it's difficult to prove reasonable doubt when it's one person's story that's another?
So I think my first answer to that is to question the premise, which is it a desirable thing to get convictions? Because oftentimes, not every time, but oftentimes what you have is this very gray area scenario. The reason why it's difficult to get a conviction is because forensic reconstruction is impossible. And so if the idea is, how do we make it easier to get convictions when forensic construction is impossible, my answer would be we shouldn't, right? No one should be going to jail on a shaky record, full stop. If the broader question is, how do we ensure we achieve justice, then I think that's a really interesting conversation. I am all for pulling at all the stops to protect people's liberty. I don't necessarily take the same view when it comes to protecting their privileges, right? Their right to practice a certain profession, their right to drive a car, with a certain amount of nuance infused into that view. I don't think that there's anything particularly harmful about suffering reputational consequences. And so I think there are first of all, there's the option of civil redress. There are lots of lawyers out there who do feminist civil justice related work where they sue people for, like Taylor Swift, I think, sued her assailant for $1 just so that she could prove on a balance of probabilities that it happened. And that has some value, right? And there is some worth to it that isn't measured in carceral terms. So I'd say restorative justice is one of those things if you make it meaningful. And the key, I think, and the challenge is, how do you ensure it's meaningful? How do you make sure that it isn't something that defendants are pressured into by the threat of jail, or that complainants are pressured into and operates as a bit of a check mark for a defendant who then feels like he's gotten away with it, quote unquote. So I think meaningful restorative justice is the best answer to that. But yeah, I question whether more convictions is ever going to do anything to solve the underlying problem of why we see that disconnect, not always between boys and girls or men and women, but disproportionately between boys and girls and men and women, that leave people unhappy enough to the point that they feel they need to go to the police, right? Whether or not you can prove the case criminally, socially that's a problem, and convictions don't solve that problem.
Okay, right here, yeah.
Your comment about the burden of proving consent being too high and too low, if I can tease out more of that, because that's interesting to me. If a person's in a relationship with someone and in the middle of the night they roll over and put their arm around them, this is a common experience. but at the same time, the law part of my mind is going, but this person's not consenting to this moment. Now, they have in the past, and there's a history, but obviously that's really not what I'm relying on. At least I don't think I should be legally. But is this part of what is that part of what you're saying when you're saying too high and too low?
Yes, I think in general, Canadian law recognizes that we have a sexual violence problem, as we do. And unfortunately, the response has been to try to carve out more and more and more and more specific, case-specific rules around consent that make it very easy in the scenario you've described, for example, for legal consent to technically be absent, at which point you gotta rely on the social dynamics of the situation to not get in trouble, right? This idea, and I think to your question earlier, that the message to be sending, particularly to young boys or to those who are, again, the physically dominant or bigger partner in an interaction is, there's almost no scenario where the law itself is going to immunize you from consequence. You've got to just also be a good person, right? Because otherwise, there are these little loopholes or reverse loopholes, so to speak, where you could get caught up in the justice system and find yourself with no consent defense. And the solution is to be with a partner that you are confident is not going to take that gesture as an opportunity to report you to the police, right? And take those steps.
Doesn't take advantage of
exactly.
that thing.
Yeah, exactly. And to make sure that when you're seeking that affirmative yes that you need, that you've created all the conditions to make it truly affirmative, right?
But it is a bit of a blind step.
Yeah.
Even if maybe a small.
Yeah, there's a really interesting legal question about we've got two separate doctrines. One is called reasonable steps to ensure consent. The other is called testing the waters. Reasonable steps are legal. Testing the waters is not. And the question of where you draw that line is, to date, unanswered. In part because a lot of the cases that are that minor don't find their way to trial, right? And don't generate judicial decision-making. And so we are left in a vacuum.
Okay, we want one in the back. Yes, yeah, green shirt, yeah.
My question is, how often do you deal with and how do you deal with interactions with people, either in your professional or private life, who may not fully appreciate those concepts that you so believe in?
It's for better or for worse, standard fare at Thanksgiving dinner, I think, for criminal defense lawyers. How do you defend the guilty, right? How do you do what you do? How do you defend a murderer? This is really just iterating on that theme. So I think I've had a lot of practice. And I'm not speaking up here with notes, right? Part of it is I am willing to engage with those questions if someone's asking them in good faith. And so most of what I said here, I've said a lot to people at cocktail parties, at Thanksgiving dinner, if they're willing to engage. And it often leads to a more fruitful discussion than you might imagine. There are also the ironic messages I get from survivors advocates that hope I get raped, and those people I never will engage with, but I think I usually do try my best to screen those out. When I have a big case, for example, one of my law partners or my assistant has access to my inbox, and they just kind of filter out the bad emails as much as they can so that I can keep my head free for the ones that really do seem to be genuinely inquiring.
That's so upsetting. Yeah,
it is.
Wow.
It's it just shows that there are going to be people on the fringes that will have an absolutely horrible take no matter what. And there were some of them on my side too. A couple of the support messages I got were also awful. But you just got to take those fringes and trust that they don't represent the majority.
Right, yeah. Okay, so I think we have a couple more questions. There was one over here. I want to make sure that it was asked. Yes, okay.
I'm Megan. With Canadian Civil Liberties Association, very familiar with questions about whether there should be consequences for things versus whether the government should be the one to leave those consequences out. I've appreciated your talk a lot. There's some things that I want to ask about. When you get these horrible takes, or these sort of these positions that emerge from kind of a moral panic, what is your sense right now of the way these things live on in policy, for example? So when new laws are made or when new regulations are made, and I'm thinking about things like government suggesting that there should be no bail for people who are charged with a particular kind of offense. Say, I think things around domestic violence have come into that, or mandatory minimums at a certain measure. So I'm curious about your feelings about government and how that's interacting with the work of criminal defense.
I think the popular urge to have a knee-jerk reaction to significant cases has done so much harm and resulted in so much state overreach that I don't know what to say about it, right? The push to abolish bail for a long time, the Zamir case was the poster child for why we need to make it harder for murderers to get bail. And it turns out he was innocent the whole time, right? To oversimplify a very complicated trial. What I worry about always when I see a large case inspire the bad takes is that the government will abdicate its role to work for us and instead adopt the practice of catering to us and in the short term in a way that doesn't actually serve us long term. And is this a problem with the criminal justice system? Is it a problem with democracy and the short-term nature of the 4-year term that our career politicians are always have in mind when they think about re-election? I don't know, but I do always fear that cases that inspire really strong takes, we'll see those takes translated into government. Then it's a matter of people like your organization and those who work for it to try and infuse some nuance into that. And there's room for advocacy within government. It's just not always effective depending on who's presiding over those House and Senate sessions.
But first, let me just give a proper thanks to Megan. When I was, and we at OJEN were planning the session, I was really hopeful for a talk that would be candid and explore issues in a way that was grounded and that we all in the room could relate to and engage with, and you superseded those expectations. So thank you, Megan.
Thank you for having us.
Thank you for tapping into this episode of Law Syrup. Law Syrup is produced by me, Herman Wong, and the Ontario Justice Education Network. For more information and for accompanying resources, check out ojen.ca and our show notes. See you next time.